suppose that the patentee realises that he suffered no loss at all from the infringement, but he wants an account of profits. So he begins proceedings, and the only remedy he asks for is an account of profits. From what date does interest run?
It runs from the moment he makes his election. So if his election is considered to have taken place at that stage, then it would run at that stage. So long as there are two parallel remedies.
Run from the date of the cause of action?
I'm going to come to that distinction, if I may, because that's quite an important point on this appeal. But in essence, as a matter of policy, the whole basis for paying interest is associated with as I think Lord Burroughs put it in one of his academic papers, regarding the failure to pay as itself a wrong for which compensation ought to be paid to the claimant. So it is only when one can say that all the elements crystallizing the claim are in place that there is a duty to pay, and therefore that wrong of not paying, for which interest compensates the claimant, runs. There are other reasons as well, but I think we'll pick them up as we go through. But we say it's important to read the reference to debt in section 35A in the context of an account of profits with that in mind. I was just going to say, timing-wise, if I take you to the authorities, that takes up, just as a practicality, takes too long. I've quoted probably the most important bits in the skeleton.
Right.
What I want to do is essentially run through what's in our skeleton, picking up the arguments as I go, and refer you to the passages where we find them.
Fine.
Your lordships may find when you retire you want to read round some of them, but I think it would just take too long. So there may be a couple of exceptions. Can we start at page 9 of our skeleton, paragraph 25 of our skeleton on the issues of interest and double recovery, which someone will tell me where it is in the core tab 9.
25, yeah.
Yeah, paragraph 25, which sets out section 35A. And there's a point here on construction of section 35A.
Are you sorry, on section 35A?
I think, yes, what I propose to do, I think it's more logical to do it first and then to turn to whether whether equity provides any different or distinct basis for the claim. So we set out section 35A, which refers to proceedings before the High Court for a recovery of a debt or damages, and says the court may then include simple interest on any or all part of the debt between the date when the cause of action arose and the case of etc. There is a point that's run here that the judge appeared to follow, that when it refers to a cause of action, it is not referring to a cause of action for recovery of the debt, but maybe referring to some underlying cause of action, even though the debt had not crystallized. And we will submit that that's a false reading of this section and goes against the policy which the courts have identified on a number of occasions that lie behind it. The section is limiting the ability of the court to make an award of interest to cases of a debt or damages, and when it refers to the cause of action arising, it can only be really referring to the cause of action for recovery of the debt.
The cause of action here is infringement of a patent, isn't it?
Well, no. Well, there is a cause of action for infringement of a patent, but if my learned friends wish to rely on section 35A, as they do, to recover interest, it's not a case of damages, so it doesn't fall under that head. They can only get at it by relying on the cause of action for recovery of a debt. Now we say, yes, a debt does arise. I'm getting ahead of myself. A debt does arise.
A separate cause of action.
Um,
Have you got two causes or two alternative causes of action, one for damages and one for an account, or do you have one cause of action for infringement and two possible remedies?
The word cause of action is probably loosely used in general terminology, but we say in the context of Section 35A, there is all we're interested in is when the cause of action for the debt arises, and that can only happen in a patent infringement
that
case.
suggests that your analysis is for Section 35A purposes, you divide your remedies into a cause of action for debt and a cause of action for damages.
Yes.
That's not what I would normally understand by a cause of action. A cause of action I would normally understand to be a set of facts which entitles you to claim relief from the court.
Yes.
Which is infringement, not I have a debt or I have a claim for damages.
Well, which is why I'm going to get on to what the courts have said about the purpose of this section, how they've applied it, which have in our submission been entirely consistent. That is to say that you can only get interest from the moment that the right to recover the debt actually arose. Because, as I say, only from that moment can it be said that the failure to pay the debt was a wrong for which notionally some compensation should be payable. Or indeed, that as a result of non-payment, the claimant has been deprived of the use of money which was due to him. And these are the points that we make from paragraph 27 onwards. So we refer in paragraph 26 to Lord Brandon's famous passage in BP and Hunt number 2, where he says, as in the quote, the words any debt or damages are very wide, so they cover any sum of money recoverable by one party from another, and he adheres to the view he expressed in the Eldora, and we went back to the Eldora, we've quoted that at paragraph 27, which was a claim for salvage, where he says the words used are any debt indicating the net is to be spread as widely as possible, apt to cover sums, whether liquidated or unliquidated, which a person is obliged to pay either under a contract express or implied or under a statute. So at what point, one asks, in parenthesis, is the defendant obliged to pay the profits? And when we come to Ricadzi, we'll see what that position is. Then we've got the Court of Appeal in BP and Hunt number 2, who had carefully looked at the actual date when it could be said the liability of Mr. Hunt to pay BP.
7th of December 1971 was the date when the contract was frustrated.
It was the date when the contract was frustrated. So that various dates were put forward, and they were very keen to work out what the appropriate date was, as indeed had been Robert Goff, Mr. Justice Robert Goff at first instance. As we say in paragraph 30, it's relevant to have in mind the constant mantra of the courts that Section 35A awards of interest are compensatory only, and that compensation is recompense for being deprived of use of the money which should have been paid earlier. And that's, when we've given one quote, there are many. In fact, we've given two quotes. One is Mr. Justice Robert Goff in the underlined passage where he's identifying the principles underlying the award of interest, because the plaintiff has been deprived of the use of the money which was due to him. And then similarly, Carrasco and Johnson, which is the leading authority of the Court of Appeal on the principles to be applied, under Section 35A compensate claimants for being kept out of money which ought to have been paid to them. And as we say, if one looks at the claim in this case, obviously this isn't a claim to damages. It can only find its way within Section 35A on the basis of a claim to a debt. And the idea that interest awarded on that basis can be awarded for things done before the debt actually arose is, we say, contrary to the authorities. We've quoted Mr. Justice Robert Gough himself quoting Lord Wilberforce on this point, where a wrongdoer has failed to pay money which he should have paid. Justice requires he should have paid interest over the period for which he has withheld the money, not for an earlier period, we say. And then we get to Lord Borough's explanation of the logic of the compensatory purpose of interest when awarding it in respect of a liability which is not compensatory at all. So that's the oddity, if you like, or the proposed oddity of interest on, for example, restitutionary claims or other non-damages claims. And his explanation, which we've underlined, the failure to pay the sum which is legally due, whether a debt or damages, is in itself being treated as a wrong. It's a wrong that triggers compensation for the loss of the use of the money caused by the failure to pay the sum legally owed, with the wrong being committed at the date of the cause of action for the debt or damages. And that's what we say is the proper reading of Section 35A, and it's consistent with this whole compensatory purpose. And we quote from Lord Denning in Jefferton G at 36. It's not compensation for the damage, it is awarded to a plaintiff for being kept out of the money that ought to have been paid. And therefore it should only be awarded from the date the defendant ought to have paid and didn't, because it's only from that time the plaintiff is said to make that. So we say that consistent statements in the authorities and the academic papers to that effect, and that was why the Court of Appeal in BP and Hunt were so concerned to work out the precise date at which it could be said the money ought to have been paid. And as we say in 38, there are therefore many cases where it turns out that money had to be handed over, but interest, there's no entitlement to interest under Section 35A, and a good example of that is the decision of Lord Justice Arnold in Agbarje. That was a case, a slightly peculiar case, where a claimant was expelled from a partnership, and under the partnership agreement, he was entitled to be paid the value of his shares. He didn't really want to hand over his shares at all, but they'd been taken from him. And there was a big argument about how much they were worth. And ultimately, it went to the High Court, who valued the shares at 21,000 and something, and directed that payment should be made to Mr. Agbarje of that money with interest. And the question arose, was it right to order interest? And the reasoning of my Lord Justice Arnold was, when one looked at the contract, it was clear that although there was an entitlement in terms of to recover the value of the shares, that was not triggered until the share certificate had actually been delivered up by Dr. Agbaje to the partnership.
And
And
because his beef was about the quantum that should be paid.
his beef was about so he didn't really want to engage. He didn't want to give up his shares at all, I think, as you point out. He was a very unwilling participant. And he then claimed a very large sum of money, and he only got a much smaller amount. But the point of the ratio of the decision on interest was that there was no obligation to pay until he had committed this final, apparently formal act of delivering up the share certificate. And therefore, the contractual entitlement...
The point was the claim was never a claim for debt.
No.
The claim was for declaratory relief.
Yes.
Because the argument was what's the proper sum.
Yes. But it was a sum that he was always entitled to, if I can put it that way. So he'd been kept out of his money in that sense because he'd never had it, but because the cause of action for the debt had not been triggered, and this was the reasoning of your lordship, then there was no entitlement under Section 35A until that point. And as you said, it wasn't a claim under Section 35A. It wasn't a claim for recovery of a debt because no debt was ever owed. And no debt was ever owed because the certificate was never delivered up. And yes, that was a deliberate decision on his part. It's not the same as this case in a sense, but in both cases, something needed to be done before the liability to pay fell due. And only at that point does it become something that can properly be called a debt and therefore attract interest under Section 35A. That's what we say, and that's what takes us to the question of when does the defendant in an action for an account of profits for patent infringement become legally due to pay the profits over. And we say that was resolved that is resolved by the judgment of Lord Briggs for the majority of the Supreme Court in Mukadzi. As we say, the point of Lord Briggs is he is making it very clear that an account of profits against an infringer, say of a patent, is different in nature from a claim of an account of profits against a trustee, and specifically in relation to the date when the duty to account arises. Of course, the background to that was at what point can it be said that the trustee making a profit from a trust comes under a duty to pay it over to the beneficiary. So that's tab 78, which might be worth looking at, 2377 of volume 4. Starting at paragraph 20. So the judgment of the majority, and with which Lord Legate disagreed, was that the fiduciary duty to account for profits is a rule governing the conduct of fiduciaries exists in its own right. It's an inherent aspect of the undertaking of single-minded loyalty, not just a discretionary equitable remedy for the breach of some other duty, nor is it necessarily triggered by some other breach. There very often is. It may be an authorised use of the trust property or his fiduciary powers, but he must then account for that profit if it had been made from or out of his fiduciary position, not keep it for himself. The wrong which may lead to a court order for an account, and in such a case no more or less than the failure to account itself, by a fiduciary who wishes to keep a profit for himself. So if there's a breach of trust, or if he earns money in the course of his trust, to which he's not personally entitled, it belongs in equity from the beginning to the beneficiary. So there is immediately a cause of action in equity for recovery of that money. As it says, the duty to account does not depend upon the demand for an account by the principal or upon an order of the court. Certainly not the relationship between breach and damages, which has to be filled by rules of causation and mootness. And then, importantly, for our purposes, not to be the fiduciary duty to account, not to be confused or conflated with the remedy of an account. Equity makes available in property cases. In such cases, the account of property is treated as a remedy doesn't depend at all on the defendant or fiduciary. There's no prior duty to account to the owner of the intellectual property. It's imposed as a result of an election by the court. So, no prior duty to account. The defendant's not sitting on the money, owing an obligation to hand over profits to the claimant, like he would be if he was a trustee. It is triggered by, in this case, by, as the judge says, an election or an order of the court, and it is therefore, though not the same, similar to an Agbaje situation where something finally has to happen in order for the debt to emerge. Now, we submit, as we say in 43, that the judge didn't really grapple with that argument at all. He didn't refer to Lord Briggs in McCann, but he only referred to Lord Legate. And as we say, as a result, his reasoning is a bit hard to follow. We quoted his conclusion at 21, but essentially he has awarded interest from the moment of infringement because he has treated that as being when the cause of action for which interest is payable arose. And for the reasons I've given, we say that's the wrong reading of section 35A. As we say in paragraph 45,
yeah.
If the liability is a liability to account, there can't be any distinction between the date of the cause of action and the date at which the liability to account arose. And secondly, we say he seems to have erred by effectively holding, as he would have had to do, we submit, to reach this conclusion, bearing in mind what's said in McCann, that the profits being earned by the defendant were effectively held on trust until they were disgorged. And we submit that that's flat contrary to the precise distinction which Lord Briggs is drawing in McCann between a remedy in an IP case and the classic case of breach of trust. Obviously, if in some way, as profits are made, they are considered to be trust property of the patentee, then interest, it would be easy to establish an entitlement to interest because the patentee immediately can say, I'm being kept out of my money. Indeed, he could say that the trustee owed an obligation to be investing them on his behalf. And it follows that he's entitled to compensation by way of interest on that basis as well, following the line of cases on liability of fiduciaries. So we submit, as we conclude in 48, that even on the broadest construction, it doesn't enable an interest award on profits prior to the making of the election. I could just give you, for your note, Mr. Justice Cote commented on the distinction between intellectual property infringement and trusts in the Nova and Dow case, tab 90, paragraph 145, making it very clear. And we say there's no dissent from that in the majority, that it is not a case where the money is being held effectively on trust for the patentee. So, is the case any better under the equitable jurisdiction? We deal with that from paragraph 8. I was amused by a reference, I think, this morning to Mr. Hall, I think, that equity can't contradict statute. So we say it would be surprising in this case if the equitable jurisdiction somehow made the position different, because our argument under the statute is not merely a question of the wording, it's principled, because we say once you've accepted that the purpose of interest is compensatory, which it is, then until there is the duty to pay, as Lord Burrows in his article makes clear, then there's no question of compensation having to be payable at all. There's a smattering of authorities on the residual equitable jurisdiction. We start with Lord Brandon in Pintada, paragraph 8, which is oft cited, and he's referring historically to the practice of the Chancery Courts as awarding simple interest in respect of equitable remedies such as specific performance, rescission, and the taking of an account. We'll come to the meaning of taking of an account there. And Chancery Courts, he said, had further regularly awarded interest, also including compound interest, when they thought justice so demanded. That's to say, where money had been obtained returned by fraud or breach of trust in fiduciary position. Now, it turns out that that speech was lifted from, not entirely word for word, but a lot of it word for word, from sections of the Law Commission's Law of Contract report on interest from 1978, as we point out, as Lord Wolfe pointed out, and Lord Justice Mayles. And we give the citations there. When one looks at the report, the statement is quite short and doesn't support itself with authority, though the general statement appears to be entirely accurate. But there's nothing here which is purporting to give a fully defined account of the law and practice of the courts of equity. So the question arises historically, would the courts of equity award interest as ancillary relief on an account of profits imposed as a sanction in a non-trust case? So we say in paragraph 10, we say no. Indeed, it's pretty clear from the authorities that in the absence of a very particular relationship between the parties, ordinarily a trust type of relationship, they will not award interest. We start with the reference to taking of an account. Those, of course, that was the practice of the Chancery Courts of resolving contractual liability, ongoing contractual liabilities often between parties. There was a clear distinction drawn in those cases between interest awarded on an account ordinarily and in the special case of what was called an account stated, which is where the debt had been acknowledged by the debtor and there was therefore effectively a collateral contract as far as the court was concerned to pay the money plus interest. And that's the basis of the quote we've given from the Lord Chancellor in Bodham and Riley, drawing that distinction. Where there's an implied contract to pay, you've got a right to interest, but not otherwise. The fact that the sum claimed appears to be due, but it hadn't been settled or acknowledged, means that there's no basis for the payment of interest. And that was summarised, as we say, by Lord Justice Oliver. That distinction. And we say actually that's quite important because it illustrates the absence of a general equitable jurisdiction to award interest just because they've made a finding that money is due, rather similar to the approach before statute got involved in common law, though perhaps not exactly the same. And then we draw a second strand of authorities from paragraph 15, perhaps closer cases to the present, mean profits claims arising out of trespass to land. Those claims which could be to actual profits taken by the defendants or by way of compensation on a reasonable payment basis, were matters which could arise against strangers, that is to say, trespassers. But in that case, as we'll see, interest was not payable. And we say that's probably the closest analogy in the old equity cases to the present. Trespass by a stranger on land and a claim to profits in respect of that. And for that purpose, we have cited Correll and Beckford. May I just show you that one, which is bundle 1, tab 5. And you can go to page of the discussion of the facts of the case. As far as it's relevant, starts at paragraph 40. But what was going on here was that a mortgagee had ended up in possession of a property, but the debt was ultimately paid. The mortgage was paid off, but he remained in possession and earned considerable sums by way of profit. And an account was carried out following litigation, from which the sums owing to the beneficial owners of the estate, he being effectively in a position of trust whilst in possession of the property, were assessed, and the question was, should interest be payable? And the passage in question is at paragraph 281, well, it's page 281 of the report, page 41 of the bundle. And he's actually referring here to an argument that was being made by the defendant in support of the fact that interest shouldn't be payable. So where he says, under these circumstances, the case is assimilated to a simple contract debt, he's saying that's what the defendant is trying to tell me. And as he's pointed out in the previous paragraphs, that this was a mortgagee in possession who is a cestui trust in relation to the proper owner of the property. He says, under these circumstances of a cestui trust, the case is assimilated to a simple contract debt which doesn't carry interest. It's compared also to the case of mean profits improperly received by a trespasser, in which case it's clear the courts of law are not in the habit of charging parties with interest. What analogy do these cases bear to the present? And he goes on to say they don't because it's not a matter of profits being received by a trespasser where there's no privity between the parties at all. It is profits being received under an implied contract by the mortgagee to an account, receiving the rents as a trustee, receiving them to pay himself first and afterwards to account to the mortgagor. So clear distinction being drawn between a trust situation where interest on the profits could have been recovered, see Ricadzi, and the case of a recovery of profits against a stranger who's trespassed on the land, in which case...
So below the second hole punch on page 41 of the bundle, which was page 282 of the original report, it's the Master of the Rods, isn't it? He says, "This, I say, is strong proof to show that you are not to restrict a court of equity by the narrow principles applying to simple contract debts or mean profits, but that the court looks at the question as applying to mortgagee and mortgagor and gives either party interest as justice requires."
Yes.
That's a rather broad principle than you are
Well,
putting forward, isn't it?
well, we say no. If you're reading that in context, this is all about the fact that the party in possession was accessory to trust. It was a trust relationship, and that's the
What,
circumstance.
between mortgagor and mortgagee?
Well, that's how he's characterised it. Towards the end, just above 281.
Oh, once he's paid, I see.
Yes, and at the top of the page.
Yeah,
Let's
that's
consider this a case
just
of a
above
trustee.
just above 279. He says
Yes.
all the cases treat the mortgagee as soon as he is paid,
Yes,
Has
and he's
become
being
a-
paid.
holding the legal estate for the benefit of the setting of trust.
Yes. So right at the top of page 41 is his conclusion on that. So we say that's the context in which this distinction, we say it's a perfectly good distinction, which is apparent in Ricadzi as well, between the position of a stranger and the position of someone who is effectively a trustee. And that is the distinction which appears to be being drawn in the equity cases.
Was this the William Beckford who built Fonthill Abbey and squandered his father's fortune? Defended in this case.
I'm afraid I don't know.
His money certainly
it
came
sounds
from
quite
Jamaican
likely.
plantations.
It does sound quite likely
But
looking
he
at
lost it all.
It's something to do with Jamaica anyway.
Yeah, well, that's where the money came from.
Yes. Sounds likely. So we submit in summary in 19 that there's no basis for the finding that courts of equity would award interest against a defendant who committed a tort or a statutory wrong and wasn't in a position of trust or privity with the claimant. Hence, we don't find any instances in the old cases of interest being awarded on that basis in intellectual property cases. And we say that's not a matter of injustice for the reason we give at 20. One goes back to the judgment my own friend liked so much in Lifestyle Equities, the complete text of which, or the relevant bit of which, is at the top of our, at the end of our paragraph 20. An award of damages may make the infringer worse off. The infringement hasn't occurred, but an account of profits does not have this effect. Now, of course, if you, as an infringer, you make your money and then do nothing with it, you stick it under the bed, and, for example, given in is it Sempra Metals by Lord Nichols, and it simply declines in value, you are going to be worse off if the defendant comes along, claims an account of profits, and then gets interest, because you, of course, have not made any interest. And we say it's only consistent, so far as equity is concerned, with what your legate is saying there, to say, well, if you want interest on that basis, you should plead and prove that further profits have been made. And that it's accepted by my own friends in their closing submissions before the judge below that they could have made that plea and that they didn't. So it's not that they're deprived of the ability to say, subject to laws of remoteness, you made further profit on the profit. for which I ought to be able to claim. But if they're going to do that, they should plead it and prove it in the account, we say.
And if the infringer has simply put the money under the bed or lost it in some unsuccessful investment, they don't get interest at all, because that would make the infringer worse off.
Not before the ability to claim interest under Section 35A, where it becomes a debt.
Right, but they
At that point, he ought to have handed it over, and the claimant has lost money because of the delay in paying it.
But they wouldn't get equitable interest depending on what the infringer has done with the profits from the infringement.
Yes, we're certainly saying it would be open as part of the account to seek to establish further profits.
No, I follow that, but if the infringer hasn't made further profits,
yes.
The infringer made profits and then he bought a subsidiary company and it's gone into administration and is worthless. You would say no interest, no equitable interest, because the money's gone.
Yes, I wouldn't characterise a claim like that as a claim to interest as such. I mean, it's really just there's no extra profit that could be claimed. I mean, in general terms, it's unlikely to. I mean, my learned friend gives examples like, what if you'd put the money in Bitcoin and it had tripled in value? Or, there would be serious remoteness issues, I suspect, with claims of that nature. Once the profit on the actual deed had crystallised, to then look beyond it to see what else had happened. But that's really a bit outside the scope of this particular appeal.
The Vice Chancellor seems to put it on the basis of a lack of privity. That's how he explains the mean profits cases.
Yes.
We see in other cases account of profits in cases like this, IP cases. But once you've elected, the infringer is treated as carrying on the business for the patentee, for the claimant.
That's sometimes given as, I think it derives ultimately from Miss Justice Laddie. I think that's the earliest reference I've seen to that.
Well, it's approved by Lord Leggett
It's been picked up by Lord Kitchen, I think, and Lord Leggett in
and
future.
It's in Abbott and it's approved
cases.
in Lifestyle.
But one has to ask, well, what do we mean by that? I mean, it's an intellectual justification, if you like, for imposing a disgorgement remedy.
It's not only an intellectual justification, it must be the justification. The only way, I mean, one understands if someone commits a tort, you have to compensate the person who's been tortiously damaged. But that doesn't explain the account of profits. The account of profits has to be explained on the basis.
Yes.
But in some sense, once you've elected,
yes,
the claimant is saying, you've used my property to make money. I'm going to treat that as if you're doing it on my behalf, for me. And that's the only way in which you can justify it.
Yes.
But once you do that, is it not a case where there is a form of privity? I mean, it's quite an old-fashioned word, but you cease to be a mere wrongdoer. You become someone who, no doubt retrospectively, is regarded as being in a relationship with a claimant because your business is their business.
Well, we say the only consequence of or that relationship, if you like, could only be crystallised once the election is made.
Well, yes, I mean, crystallised is a word, but what's actually happening is that once you've elected, retrospectively, the business which took place some time ago is being treated as having been carried out for the benefit of the claimant.
For the purposes of
assessing how much has to be paid.
Well, we would say for the purposes of justifying the handing over of the profits. But of course, to go beyond that and say, actually I'm entitled to compensation for what you should have done with those profits, which is the basis of the claims for interest against trustees. And I know Justice Nugee has considered this in the past as well. But those cases, one says, well, the trustee actually owed an obligation at the time to invest the money and make interest on behalf of the patentee. It would be, we submit, bizarre if once after an election was made, you essentially were able to say you, the defendant, the infringer, were guilty of misconduct because you didn't apply the money in a way that you ought to have done, despite the fact that at that time there was no obligation because there was no taking of the account, because the account, as Lord Briggs says, is simply a remedy, and it doesn't take effect until after the election. And we say that kind of retrospective rewriting of the past is utterly unfair to a party who didn't know that that's what he should be doing with the money. It's quite easy in the context of a trustee, but not with a stranger of this kind.
But whether the infringer knew or didn't is not relevant. We know that from lifestyle.
Sorry, my lord.
Whether the infringer knew or didn't know that he was infringing is irrelevant, as we know from what Lord Leggatt said about that in lifestyle.
The question I'm addressing is the policy question. If you like.
No, I follow that. But it is undeniable that after an election, the account will bring into that account retrospectively profits earned from the moment of the infringement.
Well, it will assess the profits overall over the entire period which were made, and then it will
both before and after the election.
But we say that's not really a retrospective behaviour by the court. It's simply assessing what profits were made and awarding them on the basis of the statutory authority and in equity to the patentee. It's not rewriting history or requiring things to have been done which weren't done. It's simply an account of the kind that courts carry out all the time. We don't accept this retrospective characterisation of the account itself. We make that point essentially in 22, the distinction between accounts against trustees, where the obvious justification is you owe the duty to invest. My Lord Justice Nugee, Glenn and Watson. But this is simply a remedy imposed after the event. And the generalised intellectual justification for it, we submit, doesn't lead to the conclusion that interest must also be payable on some ground. I'm very short of time. We make a series of points in paragraph 23 about the judge's reasoning. Can I pick out the reference to Carberg's case, which is subparagraph 2? The judge relied on that. That was a case of rescission. This was a misrepresentation in a company prospectus. A man had paid out money for shares and then changed his mind when he saw that the company didn't look quite as strong as he thought. Proved a misrepresentation because it was said that the company was backed by certain individuals who weren't backing it. And the question was, would he get interest once the agreement was rescinded? And the court said yes. But of course, that's a case of rescission ab initio of the entire arrangement between the parties, and the defendant was effectively, given that there wasn't a contract retrospectively, was treated as sitting on the money, would have to be regarded as sitting on the money as a trustee. So it's not surprising to see that interest is awarded. Anyway, you've got the submissions we make about the specific reasoning of the judge between 1 and 10. What I should do now is move on to the next point, which is the question of rate, which we deal with from paragraph 49 of our skeleton. Now, the judge ordered payment at US prime interest rates, and we submit that was wrong in law because he applied the wrong legal tests for doing so. So far as Section 35A is concerned, and we would submit also the equitable jurisdiction, well-established purpose is compensatory, and the famous, the well-known proposition from Carrasco and Johnson, summarising the authorities we quote at the end of paragraph 50, the court needs to arrive at a rate of interest which reflects the rate at which persons with the general characteristics of the claimant would have been able to borrow the money ordered. And between 51 and 54, we set out the somewhat complicated background to how the evidence went in, but essentially Lufthansa originally seemed to be claiming interest only in equity on what they called, or what was characterised as a restitutionary basis, and we, on that basis, had addressed the question of interest on a rather different basis, namely, if we are restoring the benefit of having the money, one should do so on the basis of the rates which would be payable by the defendants, not the claimant.
As a matter of interest, what monetary difference does it make? In ballpark terms.
Someone will tell me. It does make some significant difference. I wish I could, someone will put a number on it. It's worth the argument. Right. I can say that. And it's actually quite, we would submit quite an important point. What then happened was Lufthansa changed their position, said actually it's compensatory. We say this. One can see that from skeleton that hearing. And then at that point, we filed Mr. Battrick's evidence, which you see referred to in the skeletons, Battrick 2, setting out the interest rates payable on what we perceive to be the Carrasco basis, namely what would have been the interest rates that a company in the position of Lufthansa would have borrowed, and they would have borrowed at Euribor rates because they're a German company and corporate borrowing is through its parent in euros. And that was the expert evidence in the case. But despite claiming interest on a compensatory basis, Lufthansa continued to press for US prime, which were significantly higher during the period in question, at least part of the period. And the basis for the judgment, as we set out in 55, is primarily a decision of Mr. Justice Foxton in the Commercial Court, essentially that there's a default rule in the Commercial Court that US dollar awards, and of course the profits have been awarded in US dollars in the present case, should carry interest at US prime, irrespective of whether the claimant has a US place of operations or not, and whether it's a maritime claim or not. Miss Justice Foxton said there's no contrary evidence in this case, so we're going to go with US prime as a starting point. We submit really that had little to do with the present case for the reasons we give in 56. It doesn't displace Carrasco, which is considering persons with general characteristics of the claimant. This case isn't a standard commercial court case involving contractual damages where the currency would normally be expected to reflect the currency in which the claimant suffered its loss. In any event, as we say, it was only a default position, and as we've seen, Justice Foxton only adopted it, having noted there was no contrary evidence, whereas in this case there was actual evidence. And he gave two other cases, he referred to two other cases, Mamadol, Jet Oil and Octa, we deal with that at 57A. This is, again, a reference to the practice of the commercial court where the currency of the loss and the currency of damages is US dollars. And we say, well, that would make sense, because in a damages case, currency of the loss, you would expect that to be the currency that expresses the actual loss suffered. That's why it's used as the currency of damages, probably the currency of account of the trading company. And here, of course, that would be euros, so it wouldn't work. And interestingly, Fiona Trust, which did refer to the fact that it was conventional, but one looks at paragraph 16 to 18, which we cite, and I won't ask you to look at it now, actually adopted a different rate because the claimant was not a US corporation, would not have been borrowing at US rates. The award of interest was made at a LIBOR rate, so it didn't really support the judge's decision at all. And we say a sensible approach of using Carrasco as exemplified in Fiona Trust would have led to the conclusion that the right approach was Euribor plus 1%. And the judge really didn't ever deal with our argument on Euribor. It was as if it had never happened. He was effectively dealing with the earlier arguments about where we were running UK base rate plus 1%. And asking why there was any connection between Astronics or Panasonic, that's to say the defendants, with the UK or the USA, and why it should apply to the default rule. So we say really the judge had missed the point, and the established principles, according to Carrasco, would be that interest should be awarded at Euribor plus 1% and calculated as set out in Batrick 2. Essentially, my learned friend answers that by saying, well, it's all terribly complicated in Batrick 2 because you're having to come out of dollars and into euros. So there has to be a conversion of dollars to euros in order then to value the interest at Euribor, because Euribor is only payable on euros. And then he, at the end of the period, puts it back into dollars because the award is being made in dollars. Well, we say that's not a particularly controversial thing to do. It just follows from the fact that you're having to award interest. You're awarding interest on a different basis from the currency of the award. It's not financial, I think they call it complex financial engineering. We say it's really quite a simple process. And not objectionable on its face, and that...
Is that the same whether it's awarded under Section 35A or under the equitable jurisdiction?
Yes.
Section 35A says you can award at such rate.
Yes.
What is the rate on the amount of the debt which is used if you do your calculations? It's not the Euribor rate, because that's the rate on which you award the euro sum. But by the time you've converted it and then reconverted it, it's not going to be the same rate on the dollar sum.
I think the point is that an award may be made in dollars, but when if one presupposes it's being handed over to a claimant who is a European company, it will appear in their account as euros. And therefore, there is no difficulty in applying a rate on that basis. And at that time, the value in euros and the value in dollars are the same. That's why you applied the exchange rate.
Then you reconverted at a different time. Take a case where the principal awarded is $100.
Yeah.
Convert that into euros.
Yeah.
You say it's worth 90 euros. And
Yeah.
the Euribor rate is 10%.
Yes.
So at the end of the year, you've got 99 euros.
Yeah.
If you convert it back, if the exchange rates have moved,
Right.
then suppose the dollar has strengthened.
Yes.
So your 99 euros is now only worth 90.
But that does, yes.
Then what is the rate on which you can't say it's the 10% rate because it just doesn't work.
Well, we say it does. We say what's happening here is you're working out what loss the claimant has suffered from being kept out of the money, which is the Carrasco principle, and that would have been suffered in euros at a Euribor rate. There then comes a point where that money is due and has to be paid by the defendant because the court's ordered it, which is what's going on here. That money is worth what it's worth, whether you calculate it in dollars or euros. I mean, the exchange rate only reflects, in reality, the present worth of what the claimant ought to have had, we say. I've run out of time, I think. I've made my submissions on that. You've got more submissions in our reply skeleton as well, which I haven't been through, but we just don't have the time to carry on.
Thank you very much, Mr.
I really
Burns.
invite you to read it. Thank you.
There's the tax as well.
Yes, I should, if I can take a couple of minutes. The tax point really only arises if the court finds that the interest ought to be payable by way of a disgorgement, on a disgorgement principle. In other words, on the basis that it was originally claimed. So if that justification for dollars, for a dollar rate, or
Or you
US
say
dollar,
just as you take into account tax on the profits, so you must take into
you
account
must take
tax
it,
on
yes, we say it must follow. If, however, it's compensatory and it's being done on the basis of what the defendant would have lost, we accept, that's what the claimant would have lost, we accept the claimant is taxed on the ultimate award,
Yeah.
and therefore we can't claim a double deduction.
All right. Assume from the change in seating that it's going to be Mr. Wolseley who's going to address us. Yes. Make sure you finish by 5 to 4, please, so that Mr. Purvis has time for reply.
Yes. I will deal with the issues that fall under the heading of period first, and then turn to rate. But I do not want the adoption of that logical structure to obscure the fact that, in my submission, the overall answer to this appeal on interest is really very short. We say that the decision on interest can be upheld in equity because there is an applicable, discretionary, equitable jurisdiction as to interest that enables broad brush adjustments for the time value of money, such as the one the judge made here, in aid of an equitable remedy. But even if, for whatever reason, the decision as to interest by the judge cannot be upheld as an exercise of equitable jurisdiction, two very short points of statutory construction of section 35A demonstrate that the judge's decision, in the face of the challenges that have been raised, can be upheld as an exercise of statutory discretion. Could I ask your lordships to turn up first authorities volume at tab 2. Very familiar section, but there are some points on the wording I wish to make by reference to the specific wording. Now, the words "the cause of action arose" that have been the subject of some discussion in the 6th line are clearly the starting point, the starting date by reference to which the statutory discretion arises. And as one works one's way down the 6 lines of this section and gets to the words "the cause of action arose," one might ask the question, which cause of action? One looks back up through the lines above, and there is one obvious answer: the cause of action on the basis on which the proceedings were instituted. There's a reference to proceedings in the first line. In my respectful submission, just as a matter of looking at the words of the section, the reference to the cause of action there is a reference to the cause of action that was the basis for the proceedings that had been instituted. I will obviously come on to some more submissions when I get into the detail, but I want not to distract from that very simple point of statutory construction in relation to the cause of action arose.
The cause of action here, you say, is infringement of a patent.
Of course. And there are House of Lords authorities admittedly dealing with damages cases which confirm that, and indeed stand for the principle in my submission that the words mean the same in the context of this section that they mean in the context of the Limitation Act. And that obviously puts my learned friend on the horns of a dilemma. Does he seek to distinguish those, or accept that someone seeking an account of profits is always, they may have a problem on interest, but they're always free from limitation, because the limitation doesn't run until they elect. And there are other points to be made on that, which I will get to. And that might be summarised as the cause of action as a reference to the basis of the proceedings. If your lordships are with me on that, that deals with the challenges to period. There remains the challenges to rate, and that takes me to the discussion that my Lord Justice Nugee was just having with my learned friend. In the 4th line, there is reference to all or any part of the debt or damage in respect of which judgment is given, damages, I should say. So the thing on which this statute confers a power to award interest is the sum that's in the order, or part of it if the discretion is exercised in that way. And what is it that one can apply? Simple interest at such rate as the court thinks fit. So the rubric of the section is exercise of discretion as the sum to which interest will apply, exercise of discretion as to rate, and exercise of discretion as to period. As my learned friend has explained, the basis of the challenge to the judge's decision is that he had to adopt an approach in circumstances where a different interest calculation was produced, which involved converting the judgment sum into a different currency, exercising a rate with respect to that new sum, and then converting it back. We say that's outside the rubric of the words.
Well,
It would
just
be-
explain, why would you need to convert the judgment sum into euros at all? If we're talking about rate, let us suppose that it can be objectively proved that the relevant US prime rate was 8% and the relevant Euribor rate was, I don't know, 4%. And let us suppose that it's appropriate to use Euribor. Why can't you just apply the 4% to the amount in dollars?
And indeed, mathematically, you could also apply a factor to that referable to the ratio between the end of period exchange rate and the start of period exchange rate, which would mimic mathematically the proposal that underlies the submission of the defendants. There are 2 issues with that approach. The first is that it's not actually what they asked the judge to do. They asked the judge to go to make an order of interest, which involved this calculation methodology, which is outside the rubric of the section. And that brings me to the second problem. It's no answer to that to say, oh, it's mathematically equivalent, because that argument, if right, would run just as well with compound versus simple interest. You could always say with a simple interest calculation, I propose this rate, my lord. It's actually been calculated as a simple interest rate by working out how to mimic the effect of a compound interest rate over the period. But my lord, I'm asking you to exercise your discretion to award simple interest at that rate. That would, in my respectful submission, obviously be illegitimate, and I think it's accepted to be illegitimate, and what is being proposed in relation to this currency conversion is precisely in the same boat. So the challenge to the judge's exercise of discretion as to rate is premised on a proposal which is out with the statutory regime. I always have more things to say on rate 2, but I wanted to offer those 2 very short points of statutory construction at the outset as the way through. So to succeed, turning to period, to succeed on their attack on period, my learned friends have to show that there's no jurisdiction at all in equity, or that such jurisdiction as there is in equity has been cut down by section 35A. And secondly, the statutory interest is only available from the date when the election is made to take into account of profits. I think one reason why the second of those is a contention on which the defence failed. I'll come on to more, but I'm now going to deal with equity. There are 4 basic points I wish to emphasise by way of oral submission. First, an award of interest enables justice to be done, having regard to the time value of money, and that is true in the context of account of profits as it is in any number of contexts. Second, an award of interest promotes the purpose of the equitable remedy of an account and fits with the principle underlying it. Third, the equitable jurisdiction as to interest generally is available in aid of equitable remedies, subject to the constraints that equity itself has imposed. And fourth, there is no authority or principle that stands for the proposition that there's a relevant constraint in this case. Those are the points I wish to emphasise. Our submissions as a whole are at paragraphs 3 to 38 of our skeleton. So the first point. Justice and commercial common sense for generality and in numerous contexts requires the availability in principle of adjustments for the time value of money. This is because of both inflation and the fact that there is an inherent value in earlier receipt. This observation is reflected in the judge's judgment at paragraphs 12 sub 4 and 12 sub 5, at tab 20, page 327. I'm not suggesting it's necessary to look at that. It's also, no doubt, why numerous first instance decisions have awarded interest on accounts of profits without debate. And my learned friend is having to say, in the light of his stance on period, that those decisions on interest were wrongly decided. And it's also behind the intuition in the context of the discussion earlier that justice requires interest, even in circumstances where it can be positively proved that the infringer put the £1,000 under their bed or in the garden. In terms of the number of contexts in which the basic and wide range of contexts in which the basic principle has been recognised, we've set out a number of those in our skeleton. I don't propose to go to them, but to enumerate them, there's the Shanks and Unilever context case addressed at paragraphs 27 to 29 of our skeleton, where time value of money was decided by the Supreme Court was something that fairness required as a matter of statutory construction of sections 40 and 41 on a fair share claim. There has been the observation of the Court of Appeal, by Justice Arnold, in the Frand context, that it's a widely accepted principle that the timing of the payment of money should be economically neutral. That's paragraph 26 of our skeleton. And at paragraph 30 of our skeleton, we refer to the Chief Constable of South Yorkshire police case, where the powers of the Crown Court in respect of a statutory pension scheme had to be construed to determine whether the Crown Court, in the absence of express provision, had power to allow interest when it was awarding ancillary to an award on a claim concerning backdated pensions. And I do invite your lordships to consider paragraphs 51 to 54 of that decision. I won't go to it now. Of course, lastly on this topic, there has been this whole issue of the time value of money has been the subject of extensive discussions in the line of cases, Sempra, Littlewoods, Prudential. We cite those in our skeleton. But I should, my lords, make clear, it is not our case that interest is available here because there is a time value of money benefit that can be regarded as an enrichment at the expense of the patentees so as to give rise to an unjust enrichment claim. The analysis in Prudential was specifically concerned with the issues that arise over regarding time value of money as an enrichment of that kind. That's not, we're not relying on those cases so as to rely on it being such an enrichment. We rely on it for the dicta quoted in our skeleton about the significance of time value of money. So that's the first rather basic point, that in numerous contexts, including this one, justice points in the direction of interest being available. Second point, interest promotes the purpose of and fits with the principle underlying the Section 61 account of profits. For these purposes, I rely on the statement of purpose to which your lordships have already been taken in Lifestyle at paragraphs 155 and 156. A central purpose of intellectual property rights is to encourage and reward creativity and innovation by enabling the owner of the right to enjoy the fruits of the exploitation. I'll come back to that. The infringer is treated as if he has conducted the infringing business on behalf of the claimant, as if he has conducted. I'll come back to that. And the effect is simply to put the infringer back in the same position financially as if no infringement has taken place. Take again the example of a fruit of exploitation in the form of a lump sum of profit 10 years ago, £1,000. It's obviously a stylized example referring to cash, but it suffices for the example. If a sum of money awarded today is to enable the patentee to enjoy that 2016 fruit, the sum awarded cannot just be £1,000. What you need to identify is a sum that does a reasonable job of giving the patentee now the equivalent of having had that fruit in 2016. At least that's a stage in the process for achieving the objective of enabling the enjoyment of the historical fruit, in my respectful submission. And that is why an award of interest isn't just supported by justice in this context, but it specifically fits with the purpose of the equitable remedy we're dealing with here. And it is common ground that, albeit it's invoked, to use my learned friend's word, by statute, this is an equitable remedy. The general principle in play is also demonstrated by the rescission judgment in Carbert's case. I ask your lordships to turn to tab 8 in volume 1. This was an innocent misrepresentation case, which sounded in a rescission. And the report of the decision as to interest is very short, page 81. The lordships will have seen this, but it's sufficiently significant that I think I should just go to it. court held that where a contract was rescinded, interest on money actually paid under it ought to be allowed, not by way of damages, but on the ground that the parties were to be restored as far as possible to their original position. Note the resonance with the purpose of an account of profits as explained by Lord Legate. And then simple interest is awarded at 4%. There's no question of this being the fraud-based compound interest type situation. But my learned friend, I think, seeks to explain this in part by reference to there being a relationship of privity. That's slightly odd in circumstances where the remedy in place is effectively there in order to unwind such privity as there was. And indeed, one can also see that in many contracts, such relationship as there is between the parties is somewhat attenuated. But most significantly, that's not the basis of the decision as reported in this report. The basis for awarding interest was that the parties were to be restored as far as possible to their original position, and therefore in equity, discretion was exercised to award simple interest. The defendants argue that an award would not promote the purpose of an account because there's no proved benefit. If you want it to fit with the purpose of an account, you can attempt that, but you need to plead and prove the benefit, the profit. And they say that there's no injustice because of the availability of that. Two observations about that submission. First, well, three observations. First, it fails the justice test by reference to the example of £1,000 under the bed. Secondly, it fails to be sensitive to the fact that just as if you said my profit was 1,000, you'd need to clarify that by giving a currency. When you say my profit was £1,000, in order to understand the value of that profit, you'd need to know the date.
Well, your point essentially is that you are no worse off than if you had paid £1,000 in 2016, if you are ordered to pay £1,000 plus interest in 2026.
Certainly, that's the purpose of the court's interest calculation.
You may be worse off in nominal terms, but in real terms, you're no worse off.
Economically neutral is the phrase, and that's the purpose of the exercise. The submission isn't that the award of simple interest achieves that perfectly, but it's an instrument the court has to try in a reasonable way to adjust
the
for
instrument the
for that
court uses rather than indexation, for example.
Indeed, exactly, my lord. Right. So that's my second point, that an award of interest would promote the purpose of the account. That leads into my third point, which is a more general submission. The jurisdiction in equity in aid of equitable remedies is general, but subject to the limitations that the courts of equity themselves have placed on it. That's in our skeleton at paragraph 33, and in my submission, a useful case on the point is the Al-Wazir case, which is in tab 33 of volume 1. This is an interesting case in my submission because not only does it contain a statement of principle about the equitable jurisdiction, but it applies it in the meat of the decision of the court. So page 713 of volume 1. This concerns the availability of interest in connection with the enforcement of an equitable charge in circumstances where the borrower is different to the grantor of the charge. The judge, as one can see from the head note in the left-hand column, had ordered simple interest at the Judgments Act rate on the basis of an equitable jurisdiction to award interest in connection with the enforcement of an equitable charge. Sir Anthony Evans' judgment, and Lord Justice Henry agreed with his reasons on this, are, in my submission, instructive. If I could ask your lordships to turn to page 718. left-hand column at the top of the start at paragraph 30 sets it up by explaining that they're going to have to grapple with the consequences of the distinction between the Chancery Court and common law courts. Paragraph 31 describes the problem here about a potential disconnect between the position in respect of the borrower and the position in respect of the grantor of the equitable charge. Paragraph 32 explains the common law rule, and at the end moves on to the position in respect of equity in conjunction with remedies that were formerly available only in the Chancery Courts. Paragraph 33 refers to the famous passage of Lord Brandon. And specifically refers to the rule in the case of security. Paragraphs 34 and 35 go into more detail on that. And then paragraph 36. This apparently anomalous situation, in my judgment, was the direct results of the limit which the courts of equity placed on their own jurisdiction. They could supplement but not contradict the law. They could award interest when they considered it equitable to do so, but only in proceedings which were properly brought before them within their own jurisdiction. It could not and did not challenge the common law rule, and then it applies it specifically to the rule about debtors. And then the result follows from the reasoning of the proceedings. In my respectful submission, that's an authoritative statement of the basic structure of the jurisdiction in equity. It's general in respect of equitable remedies. And that's subject to the rules that the courts of equity developed, specifically by reference to respecting the law or not contradicting the law.
When he says in their own jurisdiction, I assume he means the exclusive jurisdiction of it.
Well, that raises an interesting point. So, in respect of patent infringement, the position changed in 1852. So, as I understand it, the position before statutory intervention, a bit ahead of its time, was that there was a split in the case of patents, which would illustrate the point about the difficulties with exclusive jurisdiction.
It's a common law claim because you
Yeah.
get it trumped by a jury and get a claim for damage.
Yes, on which no interest would be awarded.
People came to equity for injunction.
Indeed, and indeed an account of profits initially was only available if an injunction was awarded. The point about damages is that there might be circumstances where you'd have come to the courts of equity for assistance with the context of the common law claim, for whatever reason. But the courts of equity would not step in there and start awarding interest on damages. And in fact, that's the answer on the mean profits point. It's been explained that in Quarrel, the judge distinguished the position in respect of a mortgagee and the position in respect of a mean profits claim by reference to the concept of privity. There's a much more straightforward, well, there's another explanation for the distinction, which is that a mean profits claim for trespass is a claim for damages. So if for whatever reason the courts of equity found themselves in aid of that claim, they wouldn't step in and also award interest because that would contradict the law. The example of mean profits takes matters no further. It's not a profits claim, a mean profits claim. It's a claim for damages. And that illustrates the position.
So where does that take us to the patent infringement, where it's a bit odd because on the one hand, the underlying claim is a claim of common law, sounding in damages, but the specific remedy is an equitable one. Doesn't sound like the exclusive jurisdiction.
the remedy of an account is within the exclusive remedy, in the exclusive jurisdiction of the court, and it's the remedy that equity is coming to the aid of. So that, in my respectful submission, is the general position in respect of the equitable jurisdiction, which means that the task is to see if there is some rule in equity which excludes the jurisdiction so as not to be applicable here. And there are two cases that have been relied on by the defendants. There's the mean profit, there's Quarrel and Beckford, where there's a reference to a distinction between the position of a mortgagee and the position in respect of a mean profits claim. I've explained why that takes matters no further, and the judge reached the same view. And the other decision is Bodham and Riley, which again, as the judge has explained in the judgment, it was an account in respect of mutual dealing, completely different to an account of profits. And again, to award interest in that setting before there was an account stated would have involved contradicting the law. So it really takes matters no further in terms of what the position is for an account of profits. So, to sum up by reference to those 4 points, the availability of the jurisdiction enables the doing of justice, promotes the purpose of an account, the equitable jurisdiction in aid of equitable remedies is general, subject to any limitations that equity itself has imposed, and there's no authority that is here that I'm aware of that excludes its availability in respect of an account of profits. And the conclusion is, therefore, that there is such jurisdiction. A new point was raised today, which was to say that even if there is an equitable jurisdiction, it is limited as a result of Section 35A. That's what my learned friends have said. If they're right on Section 35A, so the statutory jurisdiction can only be exercised by reference to the date of election, equity is so constrained too. That's a new point, so I haven't gone into it to date. I made 2 points by reference to it, though. One is that in the quote from the Law Commission report that's from Lord Wolfe and Westdeutscher and in the judge's judgment, reference is specifically made to the fact that the Law Commission didn't recommend any changes to the equitable jurisdiction. So that's the best I can do on the materials I've been able to look at today. But that's my respectful submission, a strong indication that it would be surprising if Section 35A is to be construed as cutting down what otherwise was the position in respect of the equitable jurisdiction. And the second point is that there is clearly a distinction to be drawn between the position where there was a jurisdiction and then statute comes along to supplement it, and the position where there are a range of problems and some subset of the problems are solved by the statute. And that was the situation with
One
Westdeutscher.
restriction in Section 35A is that under that section, the court can only award simple interest. But in some circumstances, under the equitable jurisdiction, the court can award compound interest. So if the equitable jurisdiction has been cut down by Section 35A, that power must have been removed. And if it has, nobody's noticed.
I respectfully adopt that, my lord. So that's equity. Section 35A, the point under this heading descends to a point of construction as to whether the cause of action referred to in the 6th line of the section is a reference not to the cause of action found in proceedings, but some new form of cause of action which arises on the election. And I've given the basic reason why I say that's unsustainable by reference to the words of the Act. If few more points on that topic. The second is that there are 3 House of Lords authorities which have assisted in the construction of cause of action. We refer to them in our skeleton starting at paragraph 45. First is General Tyre, which dealt specifically with the question of when cause of action accrued in respect of a patent in the context of a damages claim. I don't want to go to that, but I do want to go.
That's in dispute. The question is, what does cause of action specifically in the context of 35A?
Indeed.
Because, as I say, I don't think it's at all in dispute that in the general law, a cause of action for patent infringement accrues in the way that the authorities establish.
And in General Tyre, the question was exactly the equivalent specific question about the predecessor to section 35A. And the point being argued in that case was that the cause of action didn't arise for the purposes of that section until the patent had been sealed as a result of section 13.4 of the Patents Act 1949. The House of Lords rejected that submission. The next House of Lords decision in the sequence is Sevcon, which
General Tyre was a damages case.
was a damages claim. It was a damages claim.
And I think Mr. Purvis accepts that in a damages case, you can get interest under section 35A back to the date of the cause of action. What he says makes all the difference is the election to ask for an account of profits.
And in relation to that point, can I ask your lordships to turn up Sevcon, which is at tab 25. This is the exact equivalent question argued by the same council that had arising in respect of the Limitation Act. And at the top of page, at 499, Mrs. Lord Mackay gave the only speech referring to General Tyre, explaining that the General Tyre decision seemed to have taken into account limitation as well, recording a submission that it was suggested that limitation could be regarded as a special case, and then rejecting that at the top of page 500. In my opinion, that jurisdiction decision has no application in the circumstances of the present case. Both in the General Tyre case and in the present case, the question is when did the cause of action accrue or arise? In the present case, no relevant difference has been suggested between the Act of 1934, which the General Tyre case decided, and the Limitation Act, etc. And in my respectful submission, that's fairly rare. There's a general finding that cause of action arose in the Interest Act means the same as cause of action accrued in the Limitation Act. And a similar cross-reference to limitation.
Is that when the debt claim arose? That's the question. Cause of action for patent infringement arose when the start of infringement. That's not in dispute. The question is, when did the debt claim arise?
It did, but where the question at issue is whether there's any basis for considering there might be a difference between the answer to that question in the context of limitation and the answer to that question in the
To be sure,
context.
this authority suggests very strongly, well, I think it decides that the cause of action arises for patent infringement, it arises on the same date for both purposes. As I say, I don't think that's actually a dispute. The question is, when did the debt claim arise? And your submission is, it's the same. But I'm not sure this authority resolves that question.
That way of putting the question, my lord, does assume against me that the words the cause of action arose in the sixth line of the section are, in the case of a debt, referring to the debt rather than simply referring back to the proceedings. And what the indication one gets, both from General Tyre, the references are in the skeleton, and Sevcon, which I've just shown, is that there is, for this purpose of construing those words and understanding how they fit, there is no difference between limitation and Section 35A. And a similar approach was taken in the Samco case of NICredit, which I won't go to, but I'll just make this point about it, because it's relevant to a point I'm going to come to. In that case, the question was, when did the cause of action arise for the purposes of interest under Section 35A? And the issue was whether the cause of action arose at the point at which the relevant transaction was entered into, in March 1990, or the later date when the full recoverable loss was identified, or was crystallised in December 1990. And the House of Lords is unequivocal in that case that for the purposes of the interest provision, the cause of action arose in March 1990. But they awarded interest in discretion from December 1990 by reference to the principle of being kept out of money. But that distinction shows that the principle of being, when we can be said to be kept out of the relevant money, doesn't guide the construction of the words cause of action arose. Second of a few points on this point about when the cause of action arose. In my respectful submission, the whole premise of this approach doesn't give due force to the actual words used by Lord Brandon in Appellant, where he rejects a technical approach to the word debt, and speaks in general terms in terms of recoverability and equity, for example. And the history in BP and Hunt was that Mr. Justice Goff dealt with the question on two bases. The first limb of his reasoning was that this was a true debt by reference to an analogy with civil claims. But he said, in the alternative, I accept what Mr. Justice Branton had said in the Eldor about it being a very wide section. Two bases. Goes to the Court of Appeal, and the Court of Appeal doesn't really deal with the issue, refers in passing to indebted, but obviously finds against the appellant, but doesn't give any reasoning on the point. And then it gets to Lord Brandon, who doesn't deal with the first limb of Mr. Justice Goff's reasoning, doesn't therefore endorse the conclusion that it was in a debt. The Section 1 claim under the 1943 Act was a debt in the way that Mr. Justice Goff had found. He went straight to the very broad reading. And in my respectful submission, there's more than a sense that this is a resuscitation of the narrow approach to debt in my learned friend's approach.
You're going to do with the rate?
Very shortly, my lord. Just a couple more points on period. Just seeing how I can cut. I should just mention the Lord Burroughs analysis referred to. I don't propose going to it, but in my respectful submission, my learned friend has it exactly the wrong way round. Professor Burroughs, as he was, isn't offering a basis on which it's appropriate to award interest when your lordships have the opportunity to look at the section relied on by my learned friend. He's offering a conceptual scheme to explain how you could understand interest as compensatory, and explaining that you could understand that way by treating them within the conceptual scheme as having acted wrongfully in not paying. It's not saying you have to have identified the duty in order for it to be permissible to award interest. Two final points on period. Agbake, the short point there is the decision of the court is that it wasn't a claim for debt or damages at all. So it really doesn't assist my learned friend on the question of when the cause of action arose. the reliance on recadcy, I should just pick up, really goes nowhere in my respectful submission, because no one was ever arguing that there was a duty in trustee sense in the context of an IP profit claim. And indeed, Lord Leggett wasn't saying that. He was saying the exact opposite. So the reference to recadcy simply doesn't assist in this question of when the duty arises for the purposes of the IP account. And the final point is an observation that a sensitivity to the date of an election of when interest could be awarded doesn't just fly in the face of the justice point before it. It makes the availability of interest dependent on things over which the defendant has control, such as when they're going to provide the information to enable the claimant to make an election. So even on those sort of more basic policy bases, it would be, in my respectful submission, a very odd result. And that echoes precisely what Mr. Justice Goff said in the context of the Frustration Act at tab 18323, letter H. So that's period. The judge awarded interest at US prime and did so in the context of US dollar sums. The attack is that because of the circumstances of Lufthansa, the only reasonable approach for the judge to take was to convert into a different currency. I've explained already why, in my view, that is out with the rubric of section 35A. It's also contrary to principle because, as a matter of substance, that approach involves two factors: a rate, which may be euro denominated, but also an exchange rate adjustment. And we've cited in our skeleton Texaco Melbourne as authority for the proposition that it's no function of the court to seek to make exchange rate adjustments by reference to the period between the assessment date and the judgment date. There's one other point I should pick up on Texaco Melbourne swiftly. Tab 28, volume 1 of the authorities bundle. This is a case where the issue precisely came up about the significant devaluation of the currency between the assessment date and judgment. And Lord Goff's reasoning is can be found on page 525 of the bundle. On the right-hand column, paragraph starting, although the difference, and he makes the point one shouldn't be mesmerised by the apparent unfairness of the result of the collapse in the currency. But the second point to draw from this passage is evident from the very end of the column, starting the proper approach. The proper approach is to identify, in accordance with established principle, the appropriate currency in which the award of damages is to be made, and to award an appropriate sum by way of damages in that currency, and also of interest in that currency to compensate for the delay between the date of breach and the date of judgment. The explanation of the proper approach there doesn't allow for any disconnect between the currency of the principal award and the currency of currency of interest. And in case it may be said that that's maybe something specific to the damages context, I should ask your lordships to look at page 526 at the bottom of the right-hand column, where he explains what the current rule was as to damages. He refers to Lord Wilberforce's rule about 7 lines up. First, it is necessary to ascertain whether there is an intention, well, I'll let your lordships read from there to the first few lines of the next column. So the point there, my lords, is that when expressing the rule that there's no gap between the currency of the substantive award and the currency of interest, he doesn't have in mind there the specific situation where the currency of the award necessarily is the currency of loss. your lordships are also all very familiar with the basic principle that the exercise of interest is to consider a person with the characteristics of the claimant and a hypothetical borrowing of the sum that's being awarded. That's what drives the selection of rates, and that again drives one to be considering rates on US dollars. And one can see that in a non-damages context quite specifically, yet again, in BP and Hunt. I won't go there, but in the first instance decision of Mr. Justice Goff at 336, after he's identified the appropriate sum effectively by way of restitution, so not a loss-related claim, a measure of benefit, he then immediately turns to the question of the approach to interest on terms of a British company wishing to borrow US dollars for purposes not specifically related to
You
operations
say
in
the
the US.
question is, what would a company in the position of Lufthansa have to pay to borrow the sum awarded, i.e. a sum in dollars?
Yeah.
If you ask what would a company in the position of Lufthansa pay to borrow an equivalent sum in euros, you're simply not asking the right question.
It's completely irrelevant, my lord, to the question which arises on the correct application of principle. In any event, any findings as to what currency payments would have been made would also be speculative.
Also what?
Would also be speculative.
Yeah.
And it isn't the basis to say, would Lufthansa have received these sums in dollars or euros? My respectful submission. So for all those reasons, the attack as to the judge's exercise of discretion as to rate cannot be sustained because it can be upheld on a compensatory basis, and that can work whether one's dealing with the jurisdiction in equity or the jurisdiction under Section 35A. And the judge made it clear, as I think it's been remarked, that in the circumstances of this case, that's a barren distinction because there weren't any relevant differences in terms of the nature of the parties on either side of that. Last point, the tax point. This is the category mistake I referred to earlier. Even if interest is being awarded under the equitable jurisdiction, and even if one has in mind the position of the defendants rather than the claimants, so that's a barren distinction on the facts of this case for the purposes of the exercise, which is the premise of the point, one is still engaged with a broad brush time value of money adjustment. One is not identifying a separate head of benefit as a proxy for what might have been pleaded and proved in the account. It's simply a time value of money adjustment. So the points about tax do not even arise on the premise on which the defendants rely. So can assist further.
Thank you very much, Mr. Moore. Mr. Purvis, do you want to reply?
A few very short points, if I may, bearing in mind how long we've all sat here today. Time value of money. In our submission, there was no such thing as what was characterised as a broad brush time value of money adjustment, which the courts will just do. And that was made absolutely clear in Prudential. Because, of course, if that was right, then the claim there to interest basic unjust enrichment claim would have been allowed. But what they did was they said it's only available because you can characterise it as a debt under Section 35A. So they fell back on the fundamental requirement that once the money was owed, and you have to look at when the money is owed, as they made clear in those passages we looked at, then interest is available on that basis, not on just some broad brush restitutionary basis. My learned friend dealt with the principle that I rely on, that the defendant should not be, and seem to accept, as I think he has to in the light of his reliance on Nugee, the principle that the defendant shouldn't be worse off as a result of an account from the position had he never infringed, and my learned friend suggested that ordering the payment of interest in circumstances where no interest had been earned never engaged that problem. If I may, I would submit that's wrong. Just as a notional and perhaps silly example, if the defendant has earned £1,000 profit from something that turns out to infringe, and puts the £1,000 in a box, and 6 years later the claimant comes along and says, oh, just in time, I found out that you've infringed and I want to recover your profits. The defendant gets out his box, proffers the £1,000. The claimant says, no, I'm entitled to £1,200. In our submission, that is the situation where the defendant is worse off than infringed. Yeah. It stands to reason that it must throw open the possibility of such cases. That's the only point we make in relation to that principle. But it is significant, we say. My learned friend dealt with the Carberg case upon which he has relied. I didn't take you to the case. I think I did mention it in my submissions. We deal with it in reply. But we go I went a little further, I think, in my submissions than what we said in our skeleton. It's not merely that there was plainly a privity there between the man who had bought the shares and the company whose shares they were. Once you have rescinded the contract and treated it as never having existed, that must be a case where, in effect, the recipient of the money has been sitting on the claimant's money. He is in a position of trust in relation to that sum, and therefore it's entirely logical, we say, following from the principles we accept, that
not a
interest
trustee.
should be paid.
The company is not a trustee for the claimant in Carberg's case. If the company had gone bust, you wouldn't be able to claim money in specie. It's just it's an equitable money claim in terms on which you get rescission, but it doesn't make you a trustee, does it?
Well, if not, we would say, if one imagines the contract never having existed, the assumption is the money was handed over, as it were, for no consideration. It's just sitting there. It must always have been the claimant's money, and therefore,
Some kind of resulting trust.
yes, precisely. It's an odd, slightly odd situation, but that was genuinely a case where the contract was rescinded. These days one would probably look at it in a different way, and by way of a restitution we claim, but that was the way it was dealt with. It's not a detailed analysis. Looks at the judgment. It's a throwaway remark. I'm not sure how far it can seriously be taken, but we'd say it's in a very sui generis category, that particular case. The mean profits case, I struggled to follow my learned friend's submission on that. He says that these were simply claims for damages, but we've explained carefully in our skeleton in paragraph, our opening skeleton on this appeal, in paragraph 15, that the mean profits cases included both damages and account cases. It was a case where the claimant could elect in relation to a claim for trespass to land.
I'm not sure
whether
that
to
Lord
go for
Justice Hoffman's analysis is current orthodoxy. It was
I'm sorry?
I'm not sure that Lord
Oh.
Justice Hoffman's analysis is current orthodoxy. It was quite revolutionary at the time.
Your Lordship is so much more familiar with this area than I will ever be. All I've got is Lord Justice Hoffman, who gave a judgment explaining that was the case. We would also say, if you look at Qural Beckford itself, the judgment clearly shows that they were looking at profits. They talk. The judge talks about profits being received by the mortgagee in possession. He was getting the rents from his tenants and receiving them, and the claimant was claiming those by way of profits. We've given those references in paragraph 16 and 17 of our skeleton. I won't go back to that, but we say it's absolutely plain that that case was for recovery of profits. But I hesitate to go any further in this particular area of law. But those are our submissions on that. The Lord Borough's point, well, actually, no, I think this was the point about restriction of equitable principles by reference to section 35A. We're not saying that equity gets cut back by the section. What we're saying is the same principle which underlies a proper interpretation of that section, as explained by Professor Lord Burrows, namely that it applies when money is properly due and represents the compensation for the wrong of failing to accord with the duty to pay, ought to be applied generally across the law, including in relation to claims to interest in equity, and there is no obvious reason to apply different policies. The General Tyre and Sevcon line of cases were clearly about the recovery of damages and don't establish anything to do with what's required in relation to a cause of action for recovery of a debt. And essentially, those cases turn on a procedural distinction as to when the damages claim could be said to have arisen, whether you needed to have issued the or published the patent.
But on your analysis, is this not right? You were submitting that the cause of action, if the patentee decides he's not going to sue for damages at all, only going to sue for an account of profits, the cause of action arises when he makes that choice. And he makes that choice when he issues his claim form. That's when his cause of action for profits arises. So how would limitation ever apply to such a claim?
Because he's elected, when he makes his election, on our understanding of the law, the liability for the debt on the basis of which entitlement to interest arises under Section 35A.
The patent is infringed in 2016. And in 2026, the patentee issues a claim form claiming an account of profits. On your analysis, he's not out of time because he didn't have a claim for debt until the moment when he chose to advance it. Is that not right? Is that not where your analysis gets us to?
No, the debt only comes in relation to his ability to make a claim for interest.
So
on
he had a
understanding.
claim, what? For,
He
had a claim for damages but not for debt in 2016?
I'm sorry, I've forgotten the years now. That you're
2016
is the
patent
date of infringement.
2026 proceedings are launched, and they only claim an account of profits.
Right.
So on your analysis, in 2016, when the patent was infringed, what, if any, cause of action did the patentee have?
In 2016, he had a cause of action for patent infringement, including damages, so far as his entitlement to recover for debt is concerned. In other words,
Does he not need to elect for damages?
yes, he would
Why does he
elect
have- Why does he have
for
a cause of action for damages in 2016 when he hasn't yet elected, but only a cause of damage for debt in 2026 when he elects?
Yes, he would have. Sorry, he would have a cause of action for patent infringement in 2016, as and when he brings a claim for that within a limitation period. He will then elect.
This is the anterior. This is
Ultimately.
the anterior question. When does a limitation period start to run? If he doesn't have a completed claim either for damages or for profits because he hasn't yet elected.
Well, it could be that, yes, when the construction for the purpose of the Limitation Act may be different from construction for the purpose of interest. But there's this, what we're concerned with here is the special case of seeking to justify interest on the basis of a claim to an account.
But then you are driving a wedge, aren't you, between General Tower on the one hand and Safran on the other?
We say, well, our reading of General Tyre and Sevcon, they're concerned with just a pure procedural issue.
Right.
And they don't really engage with the substance of the underlying right, in particular, to interest. Lords, just briefly on Texaco, we say we're not breaching the principle there. We're not suggesting, no one's inviting an adjustment to protect the claimant against adverse movement of exchange rates. Insofar as there's been a conversion here, it is simply a genuine attempt to reflect the way in which the claim to interest based on Euribor works. Your Lordships may think it's has the effects that you discussed with me earlier, but it's not the Texaco problem we submit. Unless you've got further questions for me.
I actually have one more question, which is going back to the
Yes.
rate. If I understand it, you have your dollar principal amount. In order to work out what interest to award on that up to the date of judgment, you convert it into euros, you apply the Euribor rates from
Yes.
time to time over the period.
Yes.
That gives you a euro sum, you convert that back to dollars, and that's the amount of interest that is awarded up to the date of judgment. Under Section 35A, it's standard to also continue to award interest for thereafter, is it not? Or is that not the case?
At
Or
judgment
maybe
debt,
it's replaced by the judgment act.
it's done normally at judgment debt rates, so which would give rise to other issues that I must say I haven't considered, but I'm not sure.
I think we've got enough issues already.
I certainly feel
No,
like
it's a non-point, ignorant.
I'm most grateful. Thank you.
All right,
Lord-
well, thank you very much. It will hardly surprise you to learn that we will reserve our judgments. You will get drafts in the usual way. They come under a strict confidentiality embargo, which means what it says. So the drafts can be distributed only to those on the distribution list which the court already has. Give you opportunity to correct our English, but not our reasoning, and not to introduce any new points. We would hope that in the light of the drafts you will be able to agree an order disposing of each of the appeals. If you can't agree a form of order, please make short written submissions, as short as possible, and we will make the order we think appropriate. The eventual hand down will be electronic by distribution to those on the list and release to the National Archives. I should perhaps say that if there are any redactions which you consider should be made to the draft judgments, that is the time to make them, although I'm bound to say that from my own perspective, I think there have been far too many redactions so far, and that a lot of that which the parties claim to be confidential is hardly confidential at all. Thank you all very much.
Court is able